you are setting up an obstruction of justice charge, and let's just say that instead of being president of the United States, you're a private citizen, and you insert these fact patterns, this fact pattern in, and we'll just walk through it. Sally Yates goes to the White House and warns the White House in no uncertain terms that she is very concerned about Flynn, the National Security Advisor. She is then fired in short order by the White House. Then Flynn resigns. The next day, Donald Trump pushes everybody out of the room. He's never alone in the Oval Office. There are always 20 people wandering around. He kicks everybody out. He keeps the FBI director in and then says, I want you to drop this. Will you drop this investigation? The FBI director refuses. Donald Trump then fires the FBI director. The White House spokesman goes out and says, yes, he was fired because we wanted to bring the Russian investigation to an end. And then the president himself, in an admission against his own interest, tells Lester Holt, yes, I was thinking about the Russian investigation when I fired the FBI director. I understand that obstruction of justice is a state of mind crime. You have to prove somebody's state of mind, and that's pretty difficult at times. But you line up enough of these facts, you put it down on a calendar. There are a lot of prosecutors across America that would be very comfortable going in front of any federal judge trying to prove obstruction of justice under that fact pattern. Would they not, Professor?
This isn't going to be real popular, but I don't think so. My family has been pressing me on this. It's sort of like going across country with them and saying, are we there yet? Are we there yet? Everyone wants to reach that point. And you say, well, I can still see our house. It's only been 150 days or so since the inauguration. The fact is, I don't think this makes out an obstruction case. There's a couple of reasons why. First, in terms of Sally Yates being fired, there's ample reason to fire her when she told the department to stand down. And even those of us who criticized the immigration order said that, in many ways she didn't leave much of a choice at that point for being fired. So he has a reason to do that. But more importantly, obstruction of justice requires that you act to obstruct or interfere, usually with a judicial or congressional proceeding, neither of which was pending at this time. You also tend to show that it was done for a corrupt or corruptly, to use the statutory term. This doesn't meet the usual definition of that. Now, does that mean that this can't be obstruction? Of course not. It can be evidence of obstruction, but we're not there yet. This is something that was wildly inappropriate for the president to ask the FBI director, if he did ask that. And this is something worthy of investigation. And all of the facts that you tie together, Joe, are absolutely material, as you say. They can be the basis of an obstruction case. But I do think that we need to understand that right now, this is pretty thin soup for either a criminal or an impeachment proceeding.
So what would which again, as I said at the top, this is why we have you on, because you're a good lawyer and can answer this stuff. But so what would be sufficient to, what is the line that Donald Trump would have to cross for you to say, okay, perhaps this evidence shows that he was trying to obstruct an investigation?
Well, first of all, the most natural pairing is if you could show that there was a grand jury in the field when Trump took inappropriate action or tried to obstruct or interfere. That would satisfy a judicial proceeding. I don't believe that was going on at this point.
So Jonathan, it seems to me that you were telling us that if a president or a governor or an executive kills an investigation before a grand jury is impaneled, then they're pretty much free to do whatever they want to do?
No, there's two reasons why that's not the case. First of all, if a president abuses his power, he actually can be subject to impeachment. The Nixon articles of impeachment did include an obstruction count. I think there's some distinguishing factors, but it is analogous to this one. I don't believe that we satisfy that standard either. You're going to have Adam Schiff on, who was my opposing lead counsel in the last impeachment trial held in the United States Senate, the Porteous trial. And we were on either side of that case. I think that Adam would be the first to say that this is a high standard to make. But the second reason is that in terms of obstruction, the law is drafted to be narrow because you don't want every statement that a citizen makes to be claimed to be obstruction for a future proceeding. It gets too dangerously ambiguous. So courts have tried to narrow this, to keep it confined. This was an early stage before the grand jury. Now, does that mean that there's not other crimes? No. You can have false statements to federal investigators. You can have perjury. You can have lying to Congress. And as you know, Joe, one of the things that we see in this city is often it's not the original act, but the response to the scandal that gets people into trouble.
Right. And Mark Halperin, somebody wrote last night that the one maxim in Washington, D.C. that actually is true, the one saying is it's not the crime, it's the cover-up that gets you in trouble. That's proven time and time again. We'll see if that's the case here.